Clients often enter a family law practice with a specific demand. They have acquired wealth, they are about to marry, and they want a prenuptial agreement to build an impenetrable wall around their assets. But under the law of England and Wales, a prenuptial agreement does not possess the strict, standalone authority of a commercial contract. The core limitation is jurisdictional. No private contract between two individuals can ever entirely oust the oversight and jurisdiction of the family. This creates immediate friction between a client operating with a strict contract law mindset, expecting signed documents to be absolute, and the practitioner who must navigate the highly discretionary realm of family law. The practitioner's job is to accurately predict the threshold where a judge will respect the couple's autonomy and enforce the contract, versus the moment the judge will forcibly intervene to ensure fairness. Approaching a prenuptial agreement as if it were a corporate merger document is a severe miscalculation that will leave a client's assets highly exposed on divorce. To understand why these agreements are vulnerable, we have to look at the bedrock of financial distribution on divorce, Section 25 of the Matrimonial Causes Act 1973. This statute grants judges exceptionally broad powers to redistribute money, property, and pensions between spouses to achieve a fair outcome. Section 25 legally requires the court to examine a specific list of factors, demanding that the judge consider all the circumstances of the case before finalizing an order. This diagram illustrates Section 25 as an active override. The gavel icon represents the court's statutory power, which can forcibly unlock even the most securely drafted agreement if the fairness test isn't met. Among those other factors, the statute compels the court to prioritize the basic financial needs of the parties and, above all, the welfare of any minor children. For a prenuptial agreement to carry weight, it must survive the crucible of the Section 25 fairness test. Historically, courts viewed prenuptial agreements with extreme skepticism. In the early 2000s, cases like MVM and KVK showed judges beginning to attach weight to these agreements in short marriages. However, in these early instances, the contracts were primarily used to moderate the size of a financial award, rather than completely dictating asset division. That baseline shifted with the 2010 Supreme Court ruling in Radmacher v. Granatino. This diagram introduces the scales of Radmacher, illustrating the delicate balance between party autonomy and the court's statutory obligations. The Supreme Court established that judges should give effect to a nuptial agreement freely entered into by each party, unless, in the circumstances prevailing, it would not be fair to hold the parties to their agreement. The court also clarified that entering the agreement freely requires a full understanding of its implications. In practice, this means both parties must provide full financial disclosure and seek independent legal advice. Radmacher reversed the default position. The court now begins with the assumption that a procedurally sound agreement should be upheld, while holding a powerful veto to override it if the outcome would be demonstrably unfair. The 2013 case of BN v. MA demonstrates exactly what an enforceable agreement looks like in practice. The couple separated after a very short marriage lasting only 15 months. Before marrying, they executed a prenuptial agreement. Both parties received independent legal advice, and the document itself featured prominent warnings explicitly advising against signing if they did not wish to be bound by its terms. Upon separation, the wife applied to the court for the full range of financial orders, attempting to bypass the contract. The judge responded by questioning on what possible basis she considered it appropriate to make such a claim. The court upheld the agreement entirely, respecting the parties' autonomy to dictate their own financial separation. When a marriage is brief, produces no children, and features flawless procedural execution, a prenuptial agreement functions highly effectively, largely dictating the final order. But the Radmacher principle has strict boundaries. Fairness is not an abstract concept. It is rigorously tested against real-world vulnerabilities. In the 2014 case of Luckwell v. Lamada, the couple signed an agreement stating the husband would receive no assets or maintenance upon divorce. He received independent legal advice before signing. However, enforcing the agreement would have left him entirely destitute, falling far below the threshold of his basic financial needs. The judge accorded the agreement zero weight. The contract was discarded and the standard Section 25 rules were applied to ensure the husband's basic needs were met. The variables become even more complex over time. In the 2018 case Brack v. Brack, the couple amassed £11 million over a 14-year marriage and had 2 children. Their year 2000 prenup stipulated that the wife would receive no maintenance if the marriage failed. Evaluating the agreement in 2014, the court found strictly enforcing those original terms would be severely detrimental to both the wife and the couple's children. The judge stripped the prenup of its decisive power, demoting it to merely one of several factors to balance under Section 25. The duration of a marriage and the arrival of children act as corrosive agents to a prenuptial agreement, diluting its ability to control asset division. For practitioners, managing a client who expects an impenetrable prenup requires setting clear legal expectations early on. To withstand judicial scrutiny, an agreement must satisfy a multifaceted framework. First, procedural fairness necessitates mutual financial disclosure and independent counsel. Second, the signature must show autonomy, free from duress. Finally, the document must remain substantively fair, evaluated against the reality at the point of separation. There is an absolute red line in family practice. No private contract can legally prejudice the reasonable requirements of a minor child. Furthermore, an agreement drafted to leave a spouse destitute will invariably trigger a judicial override to satisfy basic needs. A prenuptial agreement is a highly effective tool for asset management, but its strength is entirely dependent on its alignment with the statutory demands of fairness and necessity.